And before I start, I would also like to say that I'm very grateful to be here, and I would also like to thank all the project partners for our work together, and I'm looking forward to our next project, which will be soon, I hope. So today I would like to talk about the integration of mediation in legal proceedings and the judicial system in Austria. And I will show you examples on how the Austrian legislator tried to meet the idea of appropriate dispute resolution from 2 points of view. So if you consider this as the courthouse, first I will talk about a case in which dispute resolution methods other than a civil procedure have to be tried in order to get access to the court. And in the second part of my speech, I would like to talk about possibilities to attempt mediation during court proceedings. And in between, in order to talk about the legal consequences of mediation during civil proceedings, it is necessary to give a short overview of the system of registered and non-registered mediators, because different rules apply to them. And in this regard, I will talk about 3 important aspects, namely the suspension of time limits, the confidentiality, and the enforceability. So now I would like to start with the case where ADR has to be tried before access to court is granted. So if you imagine 2 neighbors, the family Woodcutter and the family Dark, they are living next to each other in an estate of terraced houses, and their gardens are divided by a living fence. And this fence gets so high that at one point in summer, starting at noon, it blocks all the sunlight from entering the woodcutter's garden and also their kitchen, and this is why they have to use artificial light also during the day. So the woodcutters are very upset about the situation, and they try to talk to the Darks, but this is unsuccessful, so they seek legal advice. And their attorney tells them that they can't go to court immediately, but first they have to try another way. And now I would like to look on the way how this is solved in Austria. So the Austrian legislation. With the Civil Law Amendment Act in 2004, the possibility was created for neighbors to file an action for injunction if trees or plants on the neighbor's land deprive the property of air or light. And before this amendment, neighbors were only allowed to cut overhanging branches or roots, but every other impairment caused by trees or plants had to be accepted. But Article 364 of the Austrian Civil Code lists 3 requirements which have to apply. So this is only applicable if trees or plants are blocking, so it doesn't apply to buildings, for example. And the effects have to exceed the normal local level and lead to an unacceptable degradation of the property. So in the case of the woodcutter family, all these criteria are fulfilled. So the Darks have a living fence that deprives them from light, it exceeds the normal local level and degrades the property, namely the use of the garden and also of the kitchen. So if it was any other legal dispute between neighbors, the woodcutter family would have direct access to court. However, since this is the special case of Article 364, the neighbors must try an alternative dispute resolution before they can file an injunction. And so in this regard, they have 3 options. So the first one would be they can try conciliation. The second one would be to submit a request for judgment according to Article 333 Code of Civil Procedure, which we call in Austria Praetorian settlement. And the Praetorian settlement is a settlement at the court where the judge functions as conciliator. So anyone who intends to bring in an action is entitled to apply to the district court of the opponent's place of residence to attempt the settlement. Or the last option, provided the owner of the plants and trees agrees, they can try to seek the assistance of mediation. And an action can then only be filed if no agreement is reached within 3 months. And this was introduced in order not to circumvent the right to a procedure in front of the statutory judge, as stated in the Austrian constitution, and also to preserve the principle for a fair trial, like in Article 6 of the European Convention on Human Rights. And this is why a time limit was set. So the costs of the ADR method in this case are either agreed by the parties or first borne by the party who requested the amicable settlement. And if no amicable settlement of the dispute is reached, the costs will be treated as pre-litigation costs in a subsequent litigation, which means the winner will take it all. So the goal of the legislator here was, on the one hand, to offload pressure on the court system and also to sustainably improve the relationship between neighbors. Since the court or the legislator thought that mediation does not only solve legal conflicts, but also goes to the roots of the conflicts, and therefore the solution will be more sustainable than if the court decided. So let us now assume that family woodcutter chose to seek the assistance of a mediator and family dark agreed. So the Austrian law requires that this mediation has to be performed by a registered mediator. And some of you might remember the system of registered and non-registered mediators from the speech of my colleague Professor Fersch at the conferences in Vilnius this year. But for those of you who haven't been at the conference, I will just quickly explain it again. So the system was introduced in 2003, so with the Civil Law Mediation Act, and this law must be regarded as the central mediation-specific regulation in Austria. So it creates a legal framework for mediation to fulfill two objectives. On the one hand, the interest of its functionality, and on the other hand, to ensure sufficient quality standard by defining a professional profile with several requirements. So the individual regulations include the requirements and the administrative procedure for the registration of mediators, training institutions, and courses in lists to be kept by the Federal Minister of Justice. So this is one way of certification, like we heard from Agne before. So the individual, so it also regulates the rights and obligations of the registered mediators, as well as the legal consequences of mediations conducted by registered mediators. And this law was accompanied by amendments to the corresponding provisions in the Austrian Code of Civil Procedure, about which I will talk later in detail. However, this legal text is limited to civil law disputes only and without guarantees of exclusivity. So this means it's possible for mediators, even in civil law matters, to act without being registered under the Civil Law Mediation Act. So we are talking here about the non-registered mediators whose professional law foundations are derived from existing regulatory regimes. For example, the Industrial Code in Austria or laws for liberal professions like lawyers and notaries. So as a consequence, different rules apply to the mediation process, dependent if the mediation is conducted by a registered or a non-registered mediator. And in this regard, I would like to talk about three important aspects or questions that concern the interplay of mediation and civil procedures. So first, I would like to talk about the suspension of time limits. So let us assume that family woodcutter not only wants family dark to cut the hedge, but also to pay for damages in their garden, and they try to solve the issue through mediation. So what has to be considered regarding the suspension of time limits, which would be the case here regarding the time limits for claiming damages. So the consequence of mediation conducted by registered mediators is that the suspension of the beginning and of the continuation of limitation periods, as well as other substantive legal periods, also preclusive periods, for asserting the rights and claims affected by mediation during the duration of a mediation procedure. So the deadline will therefore continue after the mediation has ceased. And while in the case of family law disputes, the suspension is granted in respect of all rights and claims of the mediation parties, all other disputes require a written agreement of the parties, and in this agreement, it has to be established that the suspension also includes other claims that are not affected by mediation. This rule, however, does not apply to non-registered mediators, but there's a judicial rule for preliminary out-of-court settlement conferences, and in these cases, an expiry suspension of limitation period applies. So this was about the suspension of time limits, and now I would like to talk about a second important issue, namely the confidentiality. So let us assume that the attempt to mediate between the family woodcutter and family dark was unsuccessful, and they go to court after all. So do they have to worry about the mediator being questioned as a witness? So according to Article 18 of the Civil Law Mediation Act, mediators are in any case obliged to maintain secrecy about the facts entrusted to them in the course of mediation or otherwise known by them. they must treat all the documents prepared or handed over to them in the course of mediation as confidential. And this also extends to assistants and trainees who are involved in mediation. A breach of duty can lead to the removal from the list of mediators, and moreover, non-observance of the duty is punishable. So they could get a detention up to 6 months, or a fine for money. And despite the infringement, no punishment shall be imposed if disclosure or exploitation is justified in content and form by a public or private interest. So the Austrian procedural law provides normative safeguards for the legally recognized duty of confidentiality of registered mediators. So like I said before, there have been amendments to the Austrian Code of Civil Procedure. So Article 320 of the Austrian Code of Civil Procedure is used for registered mediators, and it is a prohibition to take evidence. But this does not apply for non-registered mediators. So for non-registered mediators, there is Article 321 of the Austrian Code of Civil Procedure, and this is only a right to refuse to give evidence. And moreover, the parties could also release them from the duty of confidentiality. And to come to the third aspect, namely the enforceability. So let us assume that the neighbors did come to a written agreement through mediation, but Family Dark does afterwards not comply with this settlement. So is it enforceable? So with the implementation of the EU Directive on Mediation, Article 433 was introduced in the Austrian Civil Code. It is subtitled Mediation Settlement. And according to this regulation, in mediation proceedings on a civil matter, a court settlement can be obtained before the district court. So the settlement is related to the content of a written agreement, more precisely on private law claims contained therein. So after a mediation agreement has been concluded, the parties are granted an enforceable title within the meaning of the Austrian execution regulation. So the existence of a written agreement resulting from a mediation procedure is regarded as a substantive prerequisite. So any out-of-court agreement reached by any other means than mediation is not sufficient. And by the way, this enforceability applies to registered and non-registered mediators, as well as domestic and cross-border mediations. So it is therefore open to parties in the course of any mediation proceedings to generate an enforceable title in accordance with Article 433A of the Austrian Code of Civil Procedure. So as a result of the systematic classification, it can be assumed that only those agreements can be considered about which the civil courts would rule in the event of a dispute. So, for example, agreements in tax and custom matters or in administrative matters are not covered. And in addition, the parties must be permitted to reach a settlement on a matter of dispute under the applicable law. So, for example, it is generally not permitted if the content of the agreement contradicts the basic values of the Austrian legal system, and in particular, if the claims are arising from prohibited transaction or, for example, the validity of a marriage. So enforceability shall also not be required if the content of the agreement is by its very nature unenforceable. So this would be, for example, they agree that they have friendly contact with each other, so this cannot be enforceable. And as a legal consequence, the agreement of which the content is contrary to substantive law or morality requires a protocol prohibition. And this article was oriented on the Praetorian settlement, which I mentioned before. So before the implementation of the EU Directive on Mediation, this settlement was used to achieve an enforceable agreement, although its application was not completely legally correct. So for the sake of completeness, reference should also be made to the possibility to get an enforceable title under the Notary Act. So this was already possible before the implementation of the EU Mediation Directive. So especially in the context of the mediation agreement, the solemnization is an adequate means of the implementation for out-of-court settlements. So on the one hand, the certification of the notarially confirmed obligation resulting from the private deed, which is the mediation agreement, must take place. And on the other hand, the notarial deed and the certificate must be combined. However, in this type of declaration of an execution order, it is important that the obliger has agreed to the enforceability. So the beneficiary doesn't have to agree with the enforceability for it to be legally effective. However, this does not fully comply with Article 6 of the EU directive, which requires that the parties apply either jointly for the enforcement or by one party with the expressive consent of the other. So this is the reason why Article 433A was introduced. And just to mention very shortly, because Sodana will have a lecture on liability afterwards, I would like to mention that registered mediators can be held liable if they violate their obligations and therefore cause an outcome in the mediation agreement which is to the big advantage of one of the parties. And therefore, registered mediators, in order to get registered, have also to take out liability insurance to the sum of 400,000 euro. So, but now to come back to our case of the woodcutter and the Dark family, this means that one, they don't have to worry about the suspension of time limits. Also, they don't have to worry about the mediator, the registered mediator, to be questioned in court proceedings. And also, they don't have to worry about the enforceability of the mediation agreement. And this was only one example, the neighborhood, of an area where there exists the obligation to seek an amicable settlement before bringing in an action at court. But there are also similar regulations in the genetic engineering law and the law on equal opportunities for people with disabilities. So now I would like to come to the second part of my presentation, namely ADR during court proceedings. So in Austria, the civil judges have the secured right to point out to institutions that are suitable for the consensual resolution of conflicts, which means also for mediation. So the legislator also created the possibility of suspending judicial procedure for the use of such institutions. And as you can see here in Article 204 of the Code of Civil Procedure, as well as Article 13 of the Federal Act on Non-Contentious Proceedings, the court is allowed or even obliged to work towards an amicable regulation and to refer to institutions which are suitable for the amicable solution of conflicts. And about the suspension of proceedings, this means to pause the civil proceedings. Either the continuation of the hearing may be suspended. This may be done either by a joint application of the parties or also ex officio by the court itself. And in non-contentious proceedings, the court has the possibility to stay the proceedings for a maximum period of 6 months. And moreover, in both procedures, the parties have the possibility to file a joint application for the stay of proceedings for a minimum of 3 months. And all these arrangements should enable the court and the parties to consider alternative procedures. However, no legislation was enacted to introduce an option to oblige parties to take recourse to a whole mediation process or any other further incentives like legal aids for the costs in amicable settlement. But in this regard, reference should be made to Article 107 of the Austrian Non-Contentious Proceedings Code. So since February 2003, so in family law, the judge has been allowed to order various measures in proceedings on custody or on personal contacts to save the welfare of a child vis-à-vis the parties, so the parents. So the judge can either order family, parent or educational counseling, an initial mediation or conciliation meeting, the counseling or training on handling force and aggression, the prohibition to departure with the child, and the removal of travel documents of the child. So regarding mediation, here the legislator intended to promote a positive environment for constructive cooperation between the parties. So the idea of the legislator was that if the court orders a mediation proceeding, that it also expresses that it deems this procedure appropriate in the special case, and therefore the parents would be more motivated and engaged in the mediation procedure. However, the legislator did not go so far as to create the possibility to order the whole mediation proceeding, so only the first initial meeting can be ordered. The idea was that this would be against the enticement for a constructive cooperation, and also the Austrian Supreme Court has already ruled that only the initial meeting can be ordered. However, there have been already empirical studies on this article, and they found that some judges would wish that they could order more than an initial meeting, because they thought that only one meeting is not enough to convince the parents to try the whole mediation process. So now I'm coming to my conclusion. What I intended to demonstrate here is that there are already initial approaches to the idea of appropriate conflict resolution in Austria. And also, there are regulations about the legal consequences of ADR in relation to civil justice in Austria, which create the possibility for parties to try ADR during court proceedings. However, for the obligatory usage of the ADR, the legislator has chosen only specific cases so far, which leads to a great heterogeneity and complexity. So therefore, it can be said that there is still great potential to enhance this idea. Maybe in form of a multi-door courthouse, which was promoted by Frank Sander, in which parties receive information about the court, about mediation or other facilities before they start the procedure, and with enough background knowledge, they would be able to choose the individually appropriate conflict resolution path before they choose the wrong track. Thank you.